Welcome to the deep dive. You, the ultimate learner. Because when you are driving down the highway and a massive 18-wheeler roars past you, it is just so easy to think that the trucking industry is entirely about physical things.
Oh, yeah, totally.
Right, like you feel the rumble of the diesel engine, you smell the burning rubber, you see the highway miles. It is just moving heavy boxes from point A to point B.
That is the illusion, yeah.
Exactly. But the reality is completely different. The real battleground, keeping that truck moving and really keeping the global supply chain from completely collapsing, is entirely invisible.
It is entirely digital.
Right. It is the digital legal plumbing. So today, our mission is to pull apart this fascinating stack of highly specialized legal notes and research regarding 2026 trucking disputes, alternative dispute resolution, and contract drafting strategies.
And I want to be clear, this is not dry legal theory.
No, not at all. This is an insider's guide. It is how the transportation industry is frantically adapting to some brutal new 2026 legal realities to avoid multi-million-dollar courtroom disasters. So, okay, let's unpack this. Because in an industry with razor-thin margins, a poorly worded contract doesn't just lose a case. It can bankrupt a fleet.
It really can. The margins in freight are notoriously tight. When you are operating with almost zero room for error, the tools for resolving disputes, well, they have to evolve faster than the trucks themselves.
Right.
Because today, it is no longer just a question of who crashed the truck or who was late. The legal battles are over who controls the digital freight record.
Who pays when the system fails.
Exactly. And what hidden mechanisms trigger the absolute second something goes wrong on the interstate.
And before we get into the massive crashes or the Supreme Court battles, I think we really need to talk about how a load of freight even gets on a truck in 2026.
Yeah, the onboarding.
Right, because the days of a broker calling a guy named Dave, agreeing on a rate, and faxing over a piece of paper, those are completely dead.
Dead and buried. The broker-carrier relationship today is strictly defined by digital contracts. Courts are ruthlessly enforcing the four corners of these agreements, but the mechanism for agreeing to them has completely shifted to the click wrap.
The click grab.
Yeah, we have moved from physical signatures to digital handshakes. The foundation for this really solidified with a 2024 precedent.
Was that the Uber case?
Yes, Wu v. Uber Tech. That case validated that a user explicitly clicking a digital I agree button is a legally binding action.
Wait, I get how clicking I agree works when I'm downloading a new smartphone software update, to get the latest emojis or whatever.
Sure.
But how does that translate to a logistics dispatcher? A dispatcher just checking a box on a screen is legally binding an entire trucking company to a multi-million-dollar liability.
That is the exact reality, and courts are applying it incredibly broadly right now.
Like how broad?
Well, take the pivotal October 2025 ruling in Rideway Express, Inc. v. Hawkeye Transportation Services, Inc.
Oh, I was reading about that one.
Yeah, so in that case, the court enforced an arbitration clause for a defamation dispute.
And the timing on that is what really threw me. The defamation happened after the freight was delivered.
Exactly.
The physical job was totally finished. So how does a digital contract from last month cover a completely different dispute today?
It comes down to a legal concept regarding the demise of a contract.
To demise.
Yeah, so the court essentially ruled that even though the physical delivery was over, the ghost of that contract lives on. Because the defamation allegedly stemmed from a dispute over that specific load of freight, the post-contract conduct gets pulled right back into the arbitration framework established by that very first digital click.
Wow. So you can't just run to a public courtroom to sue for a damaged reputation.
Yeah.
You were locked into a private arbitration room just because your dispatcher clicked a box 6 weeks ago.
You are. Which brings us to the critical 2026 drafting takeaway for the listener. Lazy digital contracting is a massive financial liability.
Right.
A broker cannot just bury a terms and conditions hyperlink at the absolute bottom of a generic website and assume they are protected.
So nobody reads those anyway.
Exactly. The legal standard now requires dedicated onboarding portals. Brokers have to build systems that force an affirmative action.
Like physically checking the box.
Right. The user must check a box next to the terms. Furthermore, the broker has to store an unalterable, time-stamped electronic record of that specific click.
So they need the receipts.
Yes. If a broker goes to court to enforce an indemnity clause and cannot produce that verifiable digital trail, the judge will throw the contract out.
All right, so the digital handshake is ironclad. The onboarding portal worked. The timestamp is logged. The liability is set. But let's look at the reality of the highway. What happens when something goes catastrophically wrong? A driver falls asleep, a truck rolls over, a load of highly sensitive pharmaceuticals is destroyed, and several cars are hit.
A nightmare scenario.
Exactly. The carrier gets sued, obviously. But if the freight broker who arranged the load suddenly declares bankruptcy to avoid the fallout, isn't there some sort of federal financial safety net? I mean, I have seen mentions of a required federal bond.
You are thinking of the FMCSA surety bond, the BMC 84.
Right, that's the one.
It is a strict federal requirement for anyone operating as a freight broker in the United States. But the limitation is the actual dollar amount. That bond is set at $75,000.
Wait, $75,000?
Yes.
That doesn't even cover the cost of the tractor, let alone the trailer or the cargo, or, God forbid, the medical bills for a multi-vehicle crash. How is that functionally a safety net in 2026?
Well, it functionally isn't, and that is the huge problem. That figure hasn't been updated since 2013.
Wow. Over a decade.
Yeah, and because inflation and modern freight values have rendered that 75 grand virtually meaningless in a catastrophic loss, the regulatory environment in 2026 has shifted aggressively. Smart carriers are no longer just looking at a piece of paper to verify the bond exists.
What are they doing instead?
They're doing forensic accounting.
They're digging into the broker's actual bank accounts.
They are heavily utilizing the FMCSA's SAFER system, that is the Federal Compliance Database. Carriers are actively scouring it to check a broker's historical liquidity and operating history.
Looking for red flags.
Exactly. They are hunting for fleeting operations.
Fleeting operations.
Yeah, these are shell companies that spin up quickly, broker a ton of high liability freight, collect the payments, and then completely vanish when a disaster happens and the bills come due. Relying on just the existence of that $75,000 bond is a guaranteed way for a carrier to be left holding $1 million bag.
Man, that terrifying gap in liability brings us to what is easily the biggest legal fight of the year.
Oh, absolutely.
The upcoming U.S. Supreme Court case involving the logistics giant C.H. Robinson. And I want to pause here and be super clear to you listening. We are absolutely not taking a side on the politics of this issue.
No, we have to remain strictly impartial here.
Right. We're merely explaining the mechanics of this because the lower circuit courts are completely split. And regardless of opinions, the financial implications of how the Supreme Court rules will restructure the entire industry.
Without a doubt. The core of this battle revolves around a federal statute called the Federal Aviation Administration Authorization Act. We usually just call it the F4A.
Okay, the F4A.
The specific legal question is whether the federal F4A law preempts or blocks state-level negligent hiring claims against freight brokers.
Let me make sure I understand the mechanics of a negligent hiring claim. This is when a plaintiff doesn't just sue the truck driver who crashed.
Right.
They sue the broker who arranged the trip, basically arguing, you should have looked at this trucking company's safety record and known they were dangerous. By hiring them, you are responsible for the crash.
That is exactly the mechanism. The plaintiff is trying to reach the deep pockets of the broker. And the circuit court split we are seeing means the law is being applied completely differently depending on where you are in the country.
It is a geographic lottery.
It really is. Some federal courts argue that as long as the broker hired a carrier with a valid federal license and insurance, the federal F4A law completely shields the broker from those state-level negligence lawsuits.
Broad preemption.
Exactly. But other courts have ruled the exact opposite, allowing plaintiffs to drag brokers directly in front of juries for negligent selection.
So the entire logistics industry is basically holding its breath right now, waiting for the Supreme Court to issue a ruling that will either offer total federal protection or just open the floodgates to thousands of new lawsuits against brokers.
Yes. And waiting is a terrible business strategy.
I can imagine.
If the Supreme Court rules against preemption, we will see a tsunami of negligent selection litigation targeting brokers. So savvy legal drafters in 2026 are not waiting. They're building contractual shields right now.
What does that look like?
They are preemptively inserting aggressively strict indemnification and hold harmless clauses into the digital broker-carrier agreements.
How does that work mechanically? If a plaintiff sues the broker, how does a clause in a digital contract save them?
The clause explicitly dictates that if the broker gets sued for negligent hiring because of something the carrier did, the carrier must step in, take over the defense, and pay the broker's legal fees.
Ah, I see.
It is a mechanism to force the financial risk back onto the trucking company, regardless of how the Supreme Court ultimately interprets the federal statute.
That makes total sense. You just contract away the ambiguity. But With all these looming Supreme Court decisions, the massive negligent hiring lawsuits, and the weaponization of indemnity clauses, it seems like relying on a traditional courtroom is incredibly dangerous and expensive,
Extremely expensive.
which is why the industry is desperately building off-ramps.
They are building massive off-ramps in the form of alternative dispute resolution, or ADR. Now, arbitration has been standard for a long time, but the real rising star of 2026 is mediation.
Mediation.
Yeah. Mediation is entirely different from arbitration. It is no longer just a stepping stone to a lawsuit. It is the primary endpoint for operational disputes. It is non-binding, it is facilitated by a neutral third party, and the two fighting companies actually keep control of the final outcome.
Rather than crossing their fingers and letting a judge hand down a verdict.
Exactly.
Well, here's where it gets really interesting. Because mediation in the trucking industry isn't just about saving money on lawyers. It is basically couples therapy for logistics.
I love that analogy. It really is.
Because in the freight world, a broker and a carrier might be engaged in a screaming match over a $50,000 damaged load of electronics on a Tuesday. But because of how seasonal freight cycles work, say, the frantic push to move produce out of California in the spring, that broker and carrier literally might need to work together again on Thursday to survive.
Right, the relationship is too valuable.
You simply cannot burn the bridge in a courtroom.
That is phenomenal. And that is why mediation is becoming the endpoint for things like freight payment issues or service failures, because it actively preserves the working relationship. A lawsuit destroys a relationship permanently.
Yeah.
Mediation allows them to vent, compromise, and get back to moving freight. And the Canadian transportation sector is light years ahead of the U.S. on this.
All right, the Canadian model under the Canada Transportation Agency is fascinating because it is so structured. They don't just suggest mediation, they basically engineer it into the DNA of the contract.
They do. Standard practice for a Canadian lease agreement in 2026 involves a very strict three-step tiered dispute resolution clause.
Walk me through the tiers.
Okay, so the mechanism works like this. Step 1 is a negotiation. But the contract legally mandates that senior executives from both sides must meet face-to-face or virtually within 15 days of the dispute.
Wow, 15 days. So they can't let it fester.
Exactly. Step 2 is mediation, which boasts an over 70% success rate in commercial cases up there.
70% is huge.
It is. And only if those first two steps completely fail do they move to step 3, which is binding arbitration.
But what stops a hot-headed logistics CEO from just saying, I am not doing couples therapy, I am angry, I am calling my litigator, and we are skipping straight to step 3?
The Canadian courts step in, and they wield a very heavy stick.
Really?
Oh, yeah. If a party tries to bypass the contractual mediation step and files a lawsuit, the court will almost certainly stay the action.
Meaning they freeze it?
Mechanically, yes. The judge freezes the lawsuit entirely. The judge will look at the CEO and say, you didn't follow your own contract. And the kicker is, the court will actively penalize that CEO by forcing them to pay the other party's legal fees just for attempting to skip the mediation line.
Oh, wow. So it literally forces everyone back to the negotiation table. So North America is doing everything possible to keep these fights out of public courtrooms. But the supply chain doesn't stop in Toronto or Los Angeles. This desperate push for private resolution is completely reshaping cross-Pacific logistics as well, isn't it?
It is overhauling the global landscape. There are two massive new Chinese regulations effective in 2026 that directly impact any U.S. or Canadian trucking company moving international goods out of the ports.
Let's get into those.
The first is the new Chinese arbitration law, which went into effect on March 1st, 2026.
And from what I understand, this new law essentially makes old-school, lazy contract drafting completely illegal. Like in the past, an American drafter might just scribble, any disputes will be handled via arbitration in Beijing at the bottom of a contract. Why doesn't that work anymore?
Because under the new law, that vague phrasing is explicitly void. To have a valid arbitration clause for cross-border logistics now, you are legally required to name a specific, recognized arbitration commission.
Like a physical entity.
Yes, you have to name an institution like SciTac. The China International Economic and Trade Arbitration Commission. It is a physical body with specific procedural rules and a set roster of arbitrators. If you don't name the specific institution, your arbitration clause evaporates and you are dragged right into the regular Chinese court system.
And absolutely no American logistics company wants to navigate a foreign court system from scratch.
No, it would be a disaster.
So what is the second regulation?
The Commercial Mediation Regulation, effective May 1st, 2026. This one is revolutionary. It creates a mechanism where settlement agreements reached through qualified mediation can be submitted directly to a Chinese court for judicial confirmation.
Okay, let me wrap my head around this. Two private companies, say a U.S. broker and a Chinese manufacturer, they argue over a massive port drayage bill.
Right.
They sit down with a private mediator in a boardroom in Chicago, they reach a compromise, and they sign a private settlement. You are saying they can then take that private piece of paper, mail it to a Chinese judge, and get it stamped.
Basically, yes.
Why do they care about that stamp?
Because that stamp turns a private boardroom handshake into a fully weaponized, instantly enforceable court order inside China.
Wow.
Yeah. If the Chinese company decides to back out and not pay, the U.S. broker doesn't have to hire Chinese lawyers to sue them for breach of contract. They just take that judicially confirmed document and go straight to seizing assets.
It makes a mediation-first clause the most powerful tool a U.S. logistics company has for cross-border trade.
Exactly.
Okay, I see the strategic value. But practically speaking, logistically, how do you even run a mediation or arbitration like that? You have a mediator sitting in Chicago, but the critical evidence, say, server logs proving a container was damaged, is sitting on a Port Authority computer in Shenzhen.
That sounds messy.
Right. How does the mediator authenticate digital evidence from across the globe without one side screaming that a PDF was forged?
That procedural nightmare is exactly what the industry solved with the newly launched 2025-2026 ICCA sourcebook.
The ICCA sourcebook.
Specifically, the Kigali Special Edition that was finalized at the Madrid Congress. You can think of the ICCA sourcebook as the ultimate procedural rulebook for digital cross-border disputes.
Oh, I see.
It provides arbitrators with a hyper-specific standardized checklist. It dictates exactly how a message from a port worker must be metadata verified and exactly how the chain of custody for electronic evidence must be maintained so that it holds up across international borders. It has become the absolute gold standard for running these cross-border virtual courtrooms.
That is fascinating. We have zoomed way out looking at cross-Pacific treaties and Supreme Court showdowns.
Oh, sure.
But some of the absolute most vicious, high-stakes legal combat in 2026 is happening on a micro level.
Inside the cab.
Exactly. It is happening right inside the cab of the truck, between the massive motor carriers and the individual owner-operators. You know, the independent drivers who lease their personal trucks to the big fleets.
The equipment leasing landscape, it is under intense regulatory fire right now. These U.S. lease agreements are governed by strict federal truth in leasing rules under 49 CFR Part 376, and the core mechanism of these rules is the concept of exclusive possession. When an independent driver signs on with a massive carrier, the regulation legally dictates that the carrier has exclusive possession, control, and use of that equipment for the duration of the lease.
So the carrier functionally owns the legal responsibility for that 80,000-pound machine.
Yes.
And whenever one massive entity has that much legal control over an independent worker, there is massive room for exploitation.
Unfortunately, yes.
There is a specific legal trap happening right now regarding how carriers handle money, specifically escrow funds and insurance chargebacks, with these drivers. Break down the mechanics of this trap. How does a simple billing issue turn into a disaster?
Let's walk through it. Say a carrier provides liability insurance for the fleet and it costs them $1,000 per truck. They deduct that cost from the independent driver's weekly settlement check. The regulations say that chargeback must be strictly capped at the actual cost.
Makes sense.
But what if the carrier decides to deduct $1,100? They pocket a hidden $100 administrative markup.
I mean, $100 seems like a standard annoying corporate fee. A breach of contract, maybe, but not a disaster.
In the past, yes. But in 2026, plaintiffs' attorneys are turning those technical violations into severe legal weapons. They aren't just suing for breach of contract, they are aggregating thousands of those $100 overcharges across an entire fleet and filing severe IIO claims.
Wait, IIA? As in racketeering?
Yes.
They are escalating a $100 hidden fee into an accusation that the trucking company is operating as an organized criminal enterprise.
Yes, or massive fraud claims. They argue it is systemic wire fraud designed to siphon money from independent contractors. So a technical violation of the truth in leasing rules is now being used to trigger devastating penalties. Leases must strictly cap premium chargebacks to the actual cost with zero administrative markup, or they risk the entire clause being voided.
So what does this all mean? I mean, for the people actually running these companies, it means that in 2026, technicalities are weaponized, and the old standard form contract, the PDF that a company has been blindly reusing since 2015, is completely dead.
It is a literal death warrant. You absolutely cannot survive 2026 with an old contract. Your agreements must be future-proofed.
Let's run through the survival checklist. What exactly needs to be in there?
First, you need survival clauses. This explicitly states that the dispute resolution mechanism survives even if the contract itself is terminated. That prevents the right-way express scenario we discussed earlier, stopping a company from dodging arbitration just because they quit the job.
Right, the ghost of the contract.
Exactly. Second, modern contracts must include class action waivers.
And the mechanism there is to stop the RACO snowball under the FAA, right?
Exactly. If one driver finds a hidden fee, a class action waiver forces that driver to fight a one-on-one battle. It prevents mass actions under the Federal Arbitration Act, where a plaintiff's lawyer pulls 5,000 drivers together into a single mega lawsuit.
What about the tech side? The trucks themselves are essentially rolling computers now.
Right, so you need new tech-specific clauses, things explicitly addressing ELD data.
Electronic logging devices.
Yes. If there is a crash, that data proves exactly when the truck braked and how long the driver had been awake. The contract must mandate the preservation of that data. You also need disclosures regarding AI dispatching.
AI dispatching.
Yeah, if an artificial intelligence algorithm is assigning routes, the contract has to establish liability. And finally, strict anti-double brokering terms.
Double brokering. That's when a legitimate trucking company takes a high-paying load, skims 20% off the top, and then secretly passes the physical freight to an unvetted, cheap, uninsured truck without telling anyone.
It is a massive liability nightmare. Your contract must completely forbid it.
Wow. We have covered incredible ground today. To summarize this for you, the listener, whether you are a logistics CEO, an owner-operator, or just someone fascinated by how the world works, the ultimate takeaway is that specificity in contracts and dispute resolution is no longer just legal paperwork.
Not at all.
It is the competitive edge that determines whether a problem costs $5,000 or $500,000.
And if we look at the trajectory of all this, well, it leads to a thought-provoking concept. Yeah, if contracts are becoming heavily digitized click wraps and dispute resolution is increasingly fast-tracked through private standardized ADR systems, how long until artificial intelligence isn't just used for dispatching, but is automatically mediating and settling these legal disputes?
Automatically?
Yeah. Imagine an AI reading the digital click wrap, instantly analyzing the truck's ELD crash data, and automatically settling the financial dispute without human lawyers ever getting involved.
Wow. An AI mediator instantly settling a multi-million-dollar dispute based on a digital handshake, all while the truck is still smoking on the side of the road.
That is definitely a provocative thought for you to mull over the next time you pass a semi-truck on the interstate. Thank you so much for joining us on this deep dive. Keep questioning the invisible systems around you and never stop looking for the digital plumbing that truly runs our world.